Welcome to Echo 315, Study Session 2, Forms of Business Enterprise, Introduction. In this study session, we'll examine the forms of business organization options available to a prospective businessman. We will also explore the procedure for incorporating a business organization in Nigeria. Learning outcomes. When you have studied this session, you should be able to 1. Explain the different types of business organization you know. 2. Describe the required procedures for incorporating a business organization in Nigeria. And 3. Explain the procedures involved in foreign investment authorization and approval. Basic form of business organization. None of the forms of business organization can be regarded as good or bad. The most suitable form in your specific case would depend on your specific need after a careful examination of the advantages and disadvantages of each type of business. Finance is applicable to all economic entities such as business firms and non-profit organizations like schools, government agencies, and churches. However, this course will focus on finance for business firms organized as 3 basic forms of business organizations. These are sole proprietorship, partnership, and company. Sole trader. A sole trader's business is run by one person. Spouses may run a sole trader's business together. As a sole trader, you are personally responsible for all the commitments of the business. For example, you must pay the debts of your business yourself if its funds are not sufficient. Sole trader is the oldest form of business organization. In Nigeria, sole traders can be found as petty traders, mechanics, vulcanizers, patent chemist stores, restaurants, electricians, etc. Though the concept of sole trader implies that the business activity has a name, most sole proprietors in Nigeria do not register their businesses. Registration may be an advantage since it gives you the exclusive right to the name in your line of business within the country. At the same time, it makes it possible for suppliers and others to check whether you are really the owner of a business. Advantages of sole traders. It does not require much skill and huge capital to set up. Decision making by a sole owner is fast and facilitates quick action. There is intimate relationship between the owner and his employees. The owner reaps the whole benefit of his handwork alone if the business succeeds, and it equips the owner with the relevant experience and opportunity to accumulate capital to expand and venture into bigger and more complex enterprises. Disadvantages of sole traders. There is total concentration of the business risks on the sole owner. He bears all the risk alone if the business fails. No opportunity for exchange of ideas, which group decision can provide. It does not enjoy economies of scale due to the small size of operation. Usually, the death of the owner brings the enterprise to an end. Partnership. A partnership is a voluntary association of 2 or more individuals operating a business for profit. The maximum number of partners is 20 persons, except where the partnership is that for practicing as legal practitioners or accountants by persons, each of whom is a legal practitioner or qualified to practice as accountant respectively. Characteristics of partnership: easier to form than company. Each partner can act on behalf of the partnership. The partners are personally liable for the business acts and the business debt of the other partners. The partnership has limited life. The partnership assets are jointly owned by all partners. Advantages of partnership: ease of formation as compared to a company, ability to combine talent and capital, low cost of organization, partnership income is not taxed, less government supervision than companies. Disadvantages of a partnership: less freedom than sole trader, limited life, less capital than company, unlimited liability and responsibility for other partners' business acts. Article of partnership: all we need to form a partnership is an oral agreement. However, we would be well advised to formalize the partnership by a written agreement. This is called the article of partnership. Some of the things we will need to include in this document will be the amount each of us is to contribute as capital, the manner in which we are going to share profit or loss, the amount each of us may withdraw, how new members are to be admitted, and whether any of us will receive salary. Company: a company is a business owned by association of persons banded together with the usual motive of making profit. We can register a new company either as a limited or unlimited company. There are two types of limited companies, namely companies limited by shares and companies limited by guarantee. In a company limited by shares, your liability is limited to your investment. In a company limited by guarantee, your liability is limited to the amount of your guarantee. In an unlimited company, your liability is unlimited. In addition, limited liability companies are of two types, namely private and public. Formation of limited liability companies. Before you can form a limited liability company, you need to file relevant documents with the Register of Companies. Two of these documents are Memorandum of Association and Article of Association. Memorandum of Association. The content of the Memorandum of Association includes the name of the company with the word limited at the end, the registered office, the objective of the company, a declaration that liability is limited, the amount of authorized capital. Article of Association. The content of the Article of Association include the rights and responsibilities of shareholders, the duties and powers of directors, how directors may be appointed, the procedure for accounting and auditing of the company's books. Share capital. There are various terms used in connection with share capital. Authorized capital is the total amount of capital stated in the Memorandum of Association which a company can issue out. Issued capital is the portion of the authorized capital which the company has issued to the subscribers. Called up capital is the proportion of the issued capital on which directors have called for payment. Paid up capital is a proportion of the called up capital that shareholders have paid. Doing business in Nigeria. All business enterprises, both local and foreign, must be registered with the Registrar General of Corporate Affairs Commissions and must comply with the internal regulations applicable to particular businesses. Under this law is the Corporate Affairs Commission, which is the body responsible for the registration and regulations of companies. Foreigners may invest and participate in the operation of any enterprise in Nigeria. By virtue of the provision of the CAMA, a foreign investor wishing to set up business operation in Nigeria is obliged to take all steps necessary to obtain local incorporation of a Nigerian company or branch or subsidiary of an existing company, which would be a separate and distinct entity from its parent company. Until so incorporated, a foreigner may not carry on business in Nigeria or exercise any of the powers of a registered company. The CAMA, however, sets out exceptions to the general rule that all foreign investors doing business in Nigeria must incorporate in Nigeria. These exceptions include companies engaged by the federal government to execute specific projects, companies undertaking approved loan projects on behalf of donor countries or international organizations, and foreign government-owned companies engaged only in export promotion activities. These exemptions are granted for a fixed period of time, usually 3 years, and may be revoked by the Federal Executive Council. Investors envisaging a long-term existence in Nigeria are therefore well advised to incorporate a local company. Foreign companies may also set up representative offices in Nigeria. A representative office, however, cannot engage in business, conclude contracts, or open or negotiate any letters of credit. It can only serve as a promotional and license office. A representative office also must be registered with the CAC. Procedure for company incorporation. The first thing that will be required to incorporate a company is to file an application for incorporation with the Registrar General of the CAC and pay a prescribed fee to reserve the name of your proposed company. You will submit your formal application in the prescribed form along with the following documents. 1. A copy of the memorandum and article of association of the company, which must be subscribed to by at least 2 persons, together holding at least 25% of the company's authorized share capital, together with evidence of payment of stamp duty. 2. A statement of the authorized share capital of the company, together with evidence that the stamp duty payable in respect of the amount of share capital has been paid. 3. A statement of the particulars of the initial directors of the company, of which there must be at least 2. 4. A notice of the situation of the registered office of the company. 5. A declaration sworn to by a lawyer that all matters preliminary to the registration of the company have been complied with. If your application is approved, a certificate of incorporation will be issued and the company can commence business, subject to its having obtained the necessary investment approvals. Foreign investment authorizations and approval. The principal laws regulating foreign investment in Nigeria are the Nigerian Investment Promotion Commission Act number 16 of 1995 and the Foreign Exchange Monitoring and Miscellaneous Provision Act number 17 of 1995. Once registration is completed, there are other approvals that the foreign investor would require. The NIPC Act 1995 provides that Any enterprise in which there is a foreign participation must be registered with the NIPC. The NIPC Act permits foreigners to own up to 100% of any business enterprise, with the exceptions of enterprises on the negative list of the Act. The negative list include enterprises involved in the production of and dealing in arms, ammunition, narcotic drugs, and physiotropic substances. In order for an enterprise in which there is foreign participation to undertake any business in Nigeria, it must obtain a business permit from the Ministry of Internal Affairs. Investors who wish to be able to remit dividend to non-resident shareholders or repatriate capital on this investment must ensure that they obtain a certificate of capital importation from the Nigerian bank through which the payment is transferred into Nigeria. A company wishing to employ expatriate must obtain an expatriate quota permission for each expatriate it wishes to employ. The expatriate quota establishes the maximum number of expatriates that a business enterprise may employ. Approval for transfer of technology and other agreements. By the virtue of the provision of the National Office for Technology Acquisition and Promotion Act 1992, any agreement under which a foreigner is to provide foreign technology, management, or assistance to a Nigerian company must be approved by the National Office for Technology Acquisition and Promotion. Fees payable for the provisions of such technology or services must also be approved by the NOTAP. Registration with the Department of Petroleum Resources. Companies that wish to engage in petroleum operations in Nigeria are required to register with the Department of Petroleum Resources, DPR. The DPR issues permit upon application in respect of oil exploration and production activities, as well as oil service activities. Fees payable depend on the category of operations for which the company applies. At the end of the first financial year, the company would be required to file tax and annual returns. In addition, the company would be required to appoint external auditors and a firm secretary. Summary. In this study session, you have learned the three basic forms of business organizations, which are sole proprietorship, partnership, and company. A sole trader's business is run by one person. The maximum number for partnership is 20 persons, except where the partnership is that for practicing as legal practitioners or accountants. We can register a new company either as a limited or unlimited company, in which the limited liability company can either be a company limited by shares or a company limited by guarantee. This is the end of study session 2. Thanks for listening.